I think we're live now because I got a notification.
Yeah.
Thank you, Sonisha. Thank you, Suraj. Hi, everyone. I'm Daanish Naithani, and I'm a PhD researcher at the University of Antwerp. Today, I'm joined by Ambika Aggarwal, who's a PhD candidate at NALSAR,
Yeah.
and Yogesh Byadwal, who's a final year student at analyst Bangalore, for this very interesting conversation on tribunals and sorry, I forgot the trials and
Tribunals and
tribulations.
tribulations.
Tribulations, yes, thank you. So today we will be discussing a little bit about the recent developments in IP law in the past 2 weeks at least. We're going to be looking at a very interesting judgment from the Supreme Court on Section 12A of the Commercial Courts Act, which is actually interpreted urgent interim relief. Then we will shift the spotlight to Ambika's work on standard essential patents, and we will ask Ambika about the context of Commercial Courts Act, the pre-litigation mediation at in SEP disputes, especially what happened at the Supreme Court in the context of the standard essential patent judgments and the WIFO dispute, which is happening before the Supreme Court and which has now again come back to the NCLAT. Yogesh will help us, he will help us make the conversation more interesting by discussing in detail about Section 12A. So I would request Ambika and Yogesh to kindly introduce themselves so that we can start. And also, please tell me about how your weekend was so far.
Ambika, you want to go ahead?
Hi, I'm Ambika. I'm doing my PhD in IP law at NALSAR. Worked there briefly as a research assistant. Also studied there, and weekend was chaotic. A lot of travel back and forth, and after about 3 years of living on campus, I'm back in Delhi for one winter to be welcomed by the infamous Delhi pollution, which honestly has left me more excited than concerned. You get to see a whole new smog before you see some real fog, and I like that aesthetic. It's a very unpopular opinion, but I like the pollution aesthetic.
I understand. Yes, Yogesh.
You understand?
I don't want to say I understand, but I'll be returning to Delhi in a month, so it's going to
Oh,
be
yeah, prepare yourself.
I was in Noida the past month, and the weather, it felt like I was in Gotham City. So dark, gloomy.
Exactly.
Nothing felt positive. So I don't like it. I'm not saying not a good experience. Uh, yeah, so coming to me, I'm Yogesh. I'm in my final year at National Law School. I have been with SpicyIP for 2 years now in various capacities, intern, fellow, right now an analyst. Uh, and the weekend was it's like 6 months are left in college, so I think anyone can figure how my days are going. So I'm living every moment. So that's about it.
great. Sounds interesting. I really miss that time of college, that last 6 months where you don't know what's going to happen, but it's like the. And I was just actually not segue, but just talking with with a friend that as you become an adult, you don't have the similar kind of experiences of going through the college life. So even if you are friends as adults, you have your own things going on. But in college, that's a one space where everybody has that common deadlines. For me, the weekend has been quite uneventful, and today it's here also gloomy. Belgium is known for its gloomy weather in winters, but I hope to make the rest good, make the most of it today. But let's coming like, pivoting a little bit. Yogesh, you saw this interesting judgment from the Supreme Court. I forgot the title of the judgment, but it discusses it's talking about a trade. It's talking about a patent dispute, but it's become like an interesting discussion on how, in the context of Section 12A, IP rights, assume a public interest role. Do you want to talk about the judgment a little bit and give us a little bit of context?
Yeah, so the judgment came around, I think, last week of October. I hadn't really read about it. I was looking at LinkedIn, all the blog posts by various firms saying that it's such a great decision, striking a balance between procedural lapse and achieving substantive justice. Until you, Danish, Swaraj, and Bharadwaj pointed out the flaws there were in the judgment. And then I looked at a looked at the judgment a little bit closer and found certain issues which I thought were very glaring. But before talking about it, I think taking a step back and talking about when Section 12A was introduced in 2018, and there were talks about how there has been a backlog of, we all know that there has been a backlog in courts. You have so many pending cases there, and that's why they brought in the amendment to say that okay, we'll have a streamlined process for judgments which are a little, for cases which are a little less complicated, and we'll try to resolve it outside the court through mediation. And that's when they brought in 12A to create an image where India is a place where you can do business easily. And also, it had to do what we have at the tribunal reasoning, that a little bit expertise is needed in these commercial cases. And that's when this amendment was brought. Uh, and coming to this case, an interesting thing was that they were talking about that their patent and design were being infringed. And the plaintiff used the word deceptive name and confusion, which is very absurd on its face. How can you talk about confusion and deceptiveness when you don't even allege there has been a trademark infringement? And the case in this, it's a little more interesting because this party had a registered trademark, but they never alleged it was being infringed. And the problems in the judgment, now coming back to the problems that I have seen. The first one is the conduct of the plaintiff himself. Now, the cause of action in this case arose back in July 2022. And from there on, the party took 3 months to correspond regarding clarifications. There was an agreement between both the parties, which was breached by the defendant. He started manufacturing fans using the similar names, and the agreement was breached. 3 months followed, there were clarifications being sent. 2 months later, they sent a cease and desist notice. And a year later, they sent a technical expert to verify if there has been infringement. And 6 months later, they finally filed the suit. So it took approximately 23 months before they filed the suit. And there is no talk about this. The judgment simply says that, and the problem with the reasoning of the court, it's saying that mere delay is not going to negate a finding of urgent relief. And why? Because they think there are two elements to this. First is that there has been substantial erosion of the market. Each day, the patent and the design are being infringed. Substantial erosion of market is happening. What about the past 23 months when it was being done? Second thing is they talk about public interest. They're saying that when an IP is infringed, public interest is inherently implicated. You have confusion in the market, which does not make sense of patents, because the public interest element in patents comes only after 20 years when someone is allowed to use that invention from the descriptions you have. Trademark, I could agree, but there has been no allegation of trademark infringement. So second thing about public interest also does not make sense. And the third problem would be the misuse with this reasoning, because they're saying that we are not going to look at delay when IP is being infringed. All strands of IP are being uniformized, saying that if your IP is being infringed, be it patents, be it trademarks, be it copyrights, urgency is going to be inherently assumed, and we're going to move ahead. And 12A, it seems like this moment that anyone could bypass 12A. And the misuse of it could be that I have a trademark registered into my name. I find a competing party using my trademark. I allow that person to build his business over a course of 3-4 years. And then I come in, say that my trademark is being infringed, destroys business. Now, Supreme Court has looked upon it, looked down upon this practice in this Power Controller versus Sumit Machines judgment. I pointed this out in my post too. And trademark allows acquiescence to be there after 5 years. So if I take 4 years, go ahead, destroy the business, it's all fine now. So this is the three main things I found very problematic in this judgment.
And this aspect, I found that in the judgment that they say that each continuing wrong is it's because there's this continuing wrong happening, that is urgency. I mean, probably I'm wrong here, but I didn't understand where that is coming from, because uh, simply in law also we look at this aspect of continuing infringement for from for to establish cause of action. Whereas what really did urgency really mean here? I didn't really understand from the judgment. What was urgency? In a lot of my frustration with in IP cases when they discuss 12A is that there is no discussion of what an urgency can be. If urgency is like, okay, public interest. the second thing that I get a little bit um, frustrated about discussion on 12A is that we don't understand that 12A has a very important perspective. It actually affects, it's important to have a stopgap measure of why we really want mediation to kick off, especially court annex mediation. Uh, there is a sanctity to court annexed mediation, which such decisions actually take away. And like concluding, I was thinking that Justice Khanna's decision, which was earlier to this, which came 2 years back, I'm not able to recall the decision's name, which that was more clearer on what an urgent interim relief is. I feel that somehow this judgment dilutes partial automation and those line of cases, which are not IP centric. Um, but the discussion, leaving 12A aside, but I think discussion on public interest and what IP uh, is all about, that was just flew over my
I
head,
mean,
even
adding
with
to
the
that,
pattern.
the
Yeah.
case involved industrial fans.
Yeah.
It's been going on for 23 months, and you're saying public interest is being harmed by using deceptively similar names to sell industrial fans. It's, it's baffling completely. Industrial fans, I really didn't understand why did you need to go in this broad-based argument saying that all strands of IP have this standard of urgency inherently assumed. That was the most problematic part.
And
Yeah,
one area where urgencies claimed all the time is standard essential patterns. I feel that every application is urgent, even though all a lot of the SEP litigations take years on end. But if anyone follows the litigation on in SEPs, um, every hearing is a fight, is a match, is a it's like it's very contested. Ambika, do you want to talk about how the important SCP disputes have really challenged this view or have cemented this view about Section 12A and urgency?
definitely cemented it. In fact, the Delhi High Court thought that the IP division specifically, that SEP disputes are so urgent that they felt the need to generate a new interim remedy in itself. So now they're issuing pro tem orders. And the interesting thing about pro tem is you don't like you. There was a judgment which said you can issue it on the first day of the trial. So no arguments necessary, no proof, nothing, no trial at all. You just come to the court and both the parties are standing there and one will say, oh, sir, this is so urgent. I need an interim order, and you get a pro tem order. Um, no application of fine whatsoever, plus also creating a new remedy that does not exist in the civil procedure code. So very interesting. But I can understand why they would feel the need to do something like this, given that SEP is like the jurisprudence is developing globally, and everybody is trying to figure out how to deal with these cases. So I guess there is this motivation for domestic courts to get a first mover advantage. So I suppose that's where they were coming from, where, okay, let's just say how progressive we are in solving these judgments. And rather ironically, also trying to show that we are so quick at resolution. But then we have the Phillips judgment that's come in last week where the patents expired about, I think, 12 years into the litigation, the patents expired, and the judgment now is pretty much again like we were discussing before we started. When does a patent even expire? If you're still talking about a patent in court 20 years after or so after its expiry, did the expiry even mean something, or are we chasing ghosts now? So so I think the Delhi High Court is trying to figure out where it stands still on the SCP cases. But like I mean, Yogesh, how do you see this will play out in the future? Of course, there is no mandate now for the mediation to happen, but do you still think that it's a maybe they will companies will still choose to mediate, or what kind of an impact do you think this has? Because I sort of see it as like we were discussing, the choice of forum. Do you want to be in a room for mediation? Do you want to go to the competition commission, as we'll discuss further, or do you want the court to gatekeep all sorts of IP decisions? I feel it's also problematic in this area. you sort of, I think one large scale impact of the 12A decision could be just the diminished importance of ADR routes as IP dispute resolution.
So, on where it could go, before this judgment came out, there were two strands of jurisprudence emerging that I could trace. One was Delhi High Court, Madras High Court, Bombay High Court, and Telangana High Court. All of them were very favorable when it came to IP cases, saying that it's an IP case, urgency is made out, we're going to grant you exemption. They were not looking at conduct that much. Harishankar, in one of the judgments, Justice Harishankar wrote that, okay, it's not going to be the case for every IP case, but in this particular case, I am going to grant you exemption. He although flagged it that for IP cases, it's not a different standard, but he didn't make an impact with that line. And there was another strand, which was Calcutta High Court, where they were saying that, okay, you're saying continuous infringement, but what we're going to do is the cause of action arose on this date, and it's a recurrent infringement happening on these dates. So what we're going to look at is institution of suit has to be counted from the date when the cause of action first arose. If it's a big delay of 2 years, we're not going to grant you exemption because I don't see any urgency here. But if it's recurrent, I'm going to look at when it came to temporary relief, I'm going to look at the last date when this happened. So for institution of suit, you have to go back to that first date. This is what was happening before. Now, after this judgment, it's very clear that the first approach, which was being adopted by all these other courts, is going to have sway over the Calcutta High Court. And this is how it's going to go forward now.
It's interesting that you say it was flagged as a one-time case because that's pretty much the format for SEP judgments also. The uniqueness of the SEPs that are being litigated, plus also in SEP cases, another thing that's very prevalent is to see the relationship between the litigating parties. So what's very obvious is that they may be going to court litigating over 7, 8 SEPs or maybe even a substantial portfolio. But while the litigation is happening, they're also sitting in their own private negotiations on other matters, on other patents, other SEB portfolios. So litigation, I feel like, when the court says, or when the court fails to distinguish that different kinds of IP can need different kinds of remedies, right? They're also sort of forgetting that IP is not like this monolithic structure. It's not adversarial in a plaintiff defendant scenario. Um, all of these plaintiffs and defendants will eventually continue doing business with each other. So even in that sense, I think mediation, the availability or the court and instituted mediation should be allowed because at least it gives a chance for businesses to keep working. Otherwise, you're literally forcing this adversarial decision where one person will be held right, one person will be held wrong. Again, in the way that you want to shape the law and economics dialogue, this also I think has even more far-reaching implications beyond what they've done for IP. But again, the limited sense of understanding on how to deal with IP nuances comes through in SEP litigations, especially in relation to the ouster of the jurisdiction of the Competition Commission of India. So the case was Ericsson between CCI and Ericsson, and a single judge way back when I think 2016 had ruled that there is harmonious construction and section 3.5 of the Competition Act, which is sort of a carve out for IP, which basically just says that nothing can be used in the Competition Act to institute proceedings where you stop a reasonable experience of enjoying IP rights. And the single judge bench said that that's fine, this is a harmonious construction, both statutes will play together, which is the most obvious conclusion that there should have been. And this is an international practice. Like the space between competition and IP is already so contested. Right? They're so differently structured and different foundations, and yet somehow trying to achieve the same goal of an equitable market experience, right? Then the appeal goes to the division bench and they just turn it around, and then they go into this assessment of like a very literal interpretation, and then which statute came first, special statute that will not derogate general law. They use all of these classic interpretation of statute nuances to eventually hold that the patent law will prevail over competition, and the Controller General's office is the one that is that is correctly positioned to look at antitrust issues arising out of IP. Now, the problem is that the Controller General's office is not positioned in that way, because the only remedy they can offer is a compulsory license. And you can't ask for a compulsory license for an SEP, because SEP comes with this entire structure of voluntary disclosure to a standard setting organization. You are already encumbered by, you are so limited in the kind of licenses you can grant, which are, the term is called FRAND licensing. So your license has to be fair, reasonable, and non-discriminatory. And it's a very loaded term. Courts are still trying to figure out what that means. Most of this is happening in private negotiations. It's based so much on private ordering. And now you're telling them that if you have to do business in our country and your negotiation isn't working out amongst yourselves, the only remedy you have is to go to the controller and ask for a compulsory license. The telecom company will never come back to work here if this ever gets enforced.
And for
Um,
who, and I also want to understand, it's a portfolio of patents of 10,000 patents. Will
yeah.
they grant compulsory licenses for all? I don't know, but I wanted also to ask you, Ambika, that when a court says that okay, patent law will prevail over competition law, it means nothing in practice, I feel.
Yeah.
uh, at the end of the day, the law on the textbook remains in the textbook, and we will keep arguing that the patent law or the competition law will prevail or not prevail or have to be harmoniously read. But the Wyford case before the NCLAT really shows you how what the problem really can be on the ground, and the solution by the division bench in its very nice judgment um, did not really think about the consequences, because these are very real problems of of companies entering into vertical agreements, not exclusively interestingly having arrangements of excluding competitors. So do you think there is I wanted to know your reflections on this statement that there is no way out, the only out of this in terms of how we think about prevailing and not prevailing in these terms.
Yeah, thankfully, at least so far, the CCI doesn't seem to have backed down in letting go of their jurisdiction so easily. So after the division bench judgment, they went to the Supreme Court, and then again, a rather disappointing judgment from the Supreme Court where there was no engagement at all. I think it was a 2 or 3 paragraph order where they've just said that if there is a private settlement, then no competition intervention required. And again, I don't understand why they did this. Maybe the case wasn't argued as effectively, or maybe the Supreme Court just wasn't interested. We don't know. But what they've written in the order is this very odd line, which reads something, I'm paraphrasing, it reads something like, if there is a question of law to be answered, then it may be answered in any future appropriate proceedings. This was the most appropriate proceeding ever. Like, the whole point of the SLP was to answer the question on law. Interestingly, the Y4 case was happening in parallel to the Ericsson case. So when Ericsson was happening in the Delhi High Court, the Y4 investigation was happening in front of the CCI. So the CCI comes out with this decision where it says, again, harmonious construction and very, very well written order, which said something on the lines of that, fine, we understand that patent gives you so many rights, but the right to exploit the market unfairly is not something that you can use as a smokescreen to protect yourself from an antitrust scrutiny. Again, logically, this makes sense. But because the Supreme Court did not engage in this issue, the vacuum maintained. And after the Supreme Court order, there was still this expectation that maybe when the next case comes up, then we might have a resolution to this issue. So, what happened in the meantime was that academics and, of course, everybody who was interested in this issue thought that since the Supreme Court says we will decide the question of law in a future proceeding, maybe we go back to the status quo and CCI can continue exercising its jurisdiction. But what the NCLAT ruling in Y4 has done, again, it cemented what Ericsson was trying to do, which is that CCI does not have jurisdiction if there is a patent involved. And this is where the NCLAT ruling is, it's so confusing. Like, I don't have a better word. It's so confusing because what do you mean that just because I hold a patent, I cannot be subjected to an antitrust scrutiny? How does ownership of a patent suddenly give me this broad right of ousting the jurisdiction of this entire public body? So that's one really problematic statement from them. The other, again, of course, is that they said the patent has already expired while the proceedings are going on. Therefore, why bother doing an antitrust scrutiny?
Yeah, and I
Again,
wanted to just like I wanted to also feel highlight that the Supreme Court, which has a general jurisdiction and looks at all kinds of cases, is not able to discuss this problem. Neither a specialized agency like the NCLAT is also not able to discuss this issue completely. So there is, we have created one of the main objectives of the Tribunal Reforms Act was to have this kind of clarity and consolidate and have tribunals, and because tribunals would have expertise and they would have they have the ability to rule on such issues. But even the tribunals themselves, I feel that there is a legitimacy of expertise within them from like with the NCLAT ruling in Vifer. Yogesh, do you want to add anything to it?
On SEPs, I think this might take you away from the discussion we are having, but I had one question. I had remember reading about patent misuse doctrine in the US, and I also remember there was a judgment by the Delhi High Court sometime back 2012. Justice Endlaw wrote it, and it was on copyright misuse. And he said that copyright is a statute in itself, and it's no longer a common law right in India. So we're going to look only in the statute, and they denied copyright misuse. And from there, I read about patent misuse, and now we're talking about SCPs, how they're talking about misuse. So first question is, in any of the judgments on SCPs, has there ever been a discussion on specifically on patent misuse? Has any party ever argued about patent misuse? And second, do you think there is a way that you could get this in India? Just something on the top of my mind hearing
so
this.
in SEP decisions, it mostly just revolves around the FRAND bargain. So
Yeah,
what they do is first you see the conduct of the parties while they were negotiating to see that if there was good faith negotiation all around.
yeah,
If there was good faith negotiation all around, then you go to see the terms of the license and you see if it meets the FRAND criteria, which mostly what courts are doing right now is to see comparable licenses which the company offered to other counterparts
yeah.
and whether the defendant, the petitioner in question, received fair treatment in that way. The question of whether they were using their portfolio for misuse has to come from an antitrust authority
Hmm.
because the court does not conduct this kind of an assessment at all. The court does not have to think about what the appropriate market is, or and so for SEPs again, there's this dynamic that your monopoly is automatic. If you hold the SEP, you're in a position to license to everybody who wants to use that patent. But generally, if you own a patent, you can decide who you want to license it to, what terms, what not. But in SEPs, you don't have that freedom. The cost of being recognized as an essential patent is that you have to give it forward.
Hmm.
Now, if you remove the antitrust authority from question, there is nobody left to judge that misuse. Now, again, they say that the controller general can do it, but it circles back to what will the controller general do? Will it give a compulsory license, which in India we've given once, and even that has been so problematic, so many reasons. The bear Natco thing. So no, I don't see where they could bring it in now, unless the court just decides on taking up the entire mandate of also engaging itself in competition law, which then it's like saying that CCI does not exist.
Yeah.
Also, interestingly, I think the only way you can resolve this is have another case go from the initiation to the appeal back to the Supreme Court, and then it's on the whim of the Supreme Court to like rectify their course or decide something different.
And it's
Until
not, and I just want to point out also, it's not that the Supreme Court has not decided CCI, sorry, competition matters. So many judgments have
yeah,
come up from in the past 2 years. Justice Nagratna had given a big judgment on Steel Authority. So it's not, I think it's more about how the things pan out in litigation, especially if you also look at the Amazon appeal that went to the Supreme Court, where they have discussed again about money decree and how that panned out. Nobody could have thought that panned out that way. So yeah, please continue. So I just wanted to highlight that.
yeah, but that's exactly right. So you have the Coal India case, and you have the Try case. That was Bharti Airtel. And so the Supreme Court, which was also very interesting, right? Because why not engage in a discussion on IP law if you engaged in exactly similar parallel discussions on the controller, on the coal controller, on the jurisdiction of Try? And in both of those cases, the Supreme Court held that, okay, this is the specialized body, so it gets first rights on deciding these issues. And if after that you feel like there is still something left to discover, then the CCI can instigate their proceedings. You could do the same thing for this as well, right? Like if you believe that the Controller General is so powerfully positioned, let them have the first rights, but then at least have the CCI come in to do their job, because the CCI is not going to look into the veracity of the patent per se, or the essentiality of the SEP. The controller can do it if they want to. The court does it all the time. The CCI, I think, at the end of the day, I think it's sort of like a misunderstanding on when the CCI should step in, and definitely a really bad interpretation of Section 3, Clause 5. This sort of, and when I was doing my research on this, I found so many other comparable statutes that have such similar language to 3.5. Like in South Korea, for instance, their legislation on this point, very specifically, is worded almost exactly the same as India's. But their decisions on harmonious construction have been completely the opposite. So uh, again, a lack of reasoning on how they've landed on this. Just just saying that, okay, this statute came, what, 2 months before the other one, therefore there is legislative intent on this should be followed. Isn't that giving too much control to legislative intent then? uh, and even if legislative intent was that strong, are you not positioned as a court of law to question that? Because again, times have changed. We didn't have SEP cases back then, we have them now. And if they demand a different treatment from the law, then why stop yourself from giving that kind of treatment?
Very well put. Um, Yogesh, do you want to add anything to the discussion? I will just kind of conclude and we'll kind of go towards concluding the session.
I think Ambika has very well covered it. And I have not read about this issue that much, but now I can see the various problems there are with this.
And thank you for sharing my frustration with the SEP decisions in India. Also, the fact that other things in India is not the only jurisdiction. In UK, also the internal license conversation is also very controversial. Um, and in EU, also they're trying to understand. Germany is very infamous, you know. And now with the UPC coming in, there are also the same challenges that have were coming before other courts have also entered into new courts. So I think we just what I really feel from the discussions on 12A and on the discussion on SCPs and the WIFO judgment is really, I think courts are, of course, what courts are important in IP because courts interpret IP rights all the time. It's about courts are doing claim construction, courts are doing the similarity tests, courts are doing everything in IP law, I feel. So that's why our engagement and our non-engagement with courts is so important. And that's why when this mandatory mediation, which is a very ancillary discussion to IP and ADR, I mean, I'm very concerned about the fact that we interpret IP rights so broadly without thinking about the policy consequences of the same. So thank you for engaging in that conversation where Ambika, you brought out your frustrations with the SCP landscape in India and the why for NCLAT's judgment, and also the fact that are we chasing ghosts now with patent rights being expired, and now there's a new amicus curiae who has been appointed, and sometimes I feel that judges who have been interpreting a patent law for a very long time, they kind of really feel, okay, this also needs clarification. So they really kind of forget that some things are done. And thank you, Yogesh, for for discussing the Supreme Court judgment on pre-litigation mediation and discussing about urgent interim relief. Urgency will always be an elusive term in the context of IP because for everyone, urgency and public interest in IP means so many different things. It depends all upon how the stakes are sometimes, I feel. So thank you so much for having this conversation. Thank you, Suraj and Sunisha. And thank you everyone who are watching us or who will watch us. If you have any questions, please reach out to us. And I don't remember the email address, but we will mention it in the down below. So thank you so much for this conversation. Bye bye.
Bye.